Good morning, I'm Michael Minton, President of Dean Mead. Thank you again for joining us. For those of you who weren't with us last evening, we had a wonderful event. To my rancher friends, next time we do this, we won't have roadkill for our dinner.
Oh my goodness.
But it was very good roadkill. As I shared with Ken Smith, it actually was a large quail, and I'm sorry if he got any shot with his meal. We'd also like to thank our other co-sponsors of today's event. Wells Fargo and their agribusiness team here today are Greg Brown and Travis Robbins with Wells Fargo. Thank you so much. McGladrey, accounting firm that we do an awful lot of work with, located in our building. Clay Warden is here, and Katrina Lawrence, who helped us develop this concept at a lunch meeting not too long ago and has been very helpful in bringing us all together. And then also with Dean Mead, the lady who has really helped pull all of this together, Karen Keene, who is at the door, and those of, absolutely, well done. And those of you who have spoke to her but have never met her, Beverly Verdon out front. Beverly is my right hand, left hand. Between she and my wife, they keep me on track. So surround myself with very smart ladies and then do what they tell me to do. We have a wonderful program today, and I want to thank all of our speakers. We have speakers who are here with us from our law firm, from McGladrey, from Wells Fargo, but we've also sprinkled in a number of speakers that we brought from different professions and specialties that will be introduced to you, but I want to thank them all for participating, and I hope you all get something from it, and I hope our speakers take away some additional information as well. Our format today is we will go from panel session to panel session. The panels will have a moderator who will introduce the other panelists. We'll encourage each panelist to make a brief statement, a bit of an overview, and then we will allow for some Q&A from the audience, and there's also the moderators have some questions that they'll ask to make sure that we address all the issues we'd like to address. If the audience has a question, please make sure you either state it loud enough or allow the panelist, the moderator, to repeat the question, because we are filming today's presentation so that we will have it available on our website and to be able to provide to those clients and friends who are unable to join us. Then we will break for a lunch presentation from the Commissioner of Agriculture, Adam Putnam, who, as I mentioned last evening, is a rising star politically in Florida, and I would have no doubt in not too many years will be involved in the national debate. But we're glad he's back in Florida right now, and we're looking forward to his comments. After lunch, Dr. Michael Swanson with Wells Fargo is going to update us on the economic trends and changes, especially macroeconomics dealing with agribusiness across the country. We'll follow that with a couple more of our panelist sessions. We promise to be done by 3:30 so that everybody can get out of here at a decent time and hopefully not get caught in the late afternoon traffic. Would you please either mute or put on vibrate your cell phones so that we don't have any of the presentations interrupted? Our first group of panelists, we thought we might as well go ahead and start with labor law issues and get that out of the way because it's going to ruin your breakfast anyway. Nikki Mooney is our moderator for our first panelist. Nikki has an undergraduate degree from FSU and her JD is from University of Florida. She practices in our litigation department and has a subspecialty dealing with employment-related issues. And she really is the lady I call on whenever I have to deal with anything having to do with a client's relationships, having to do with employees, or internally within our firm. Thankfully, we don't have to speak that often, but she is extraordinary, and she's someone on whom I rely tremendously. Nikki Mooney.
Thank you, Michael. Good morning, everybody. Is everybody awake and ready to go? All right, well, we do apologize for starting a few minutes late. There is a car that's just stopped in the middle of I-4. I got stuck behind it myself. So in any event, we're going to have two speakers with us today, one of whom is not quite here yet, so we're going to get started with, oh, he's here. Excellent news. Mr. Carlton has just joined us. We're going to talk a little bit today first with Dave Richardson, who is out of the West Palm Beach, Fort Pierce area. He is the founding attorney of the law firm of Richardson & Koch, which is located in Fort Pierce and West Palm Beach. His firm practices in labor relations and employment law, representing management. Mr. Richardson has practiced this specialty for over 34 years and represents a number of agricultural employers. Mr. Richardson is board certified in labor and employment law by the Florida Bar. He is a member of the Florida and Texas Bar, the American Bar Association, the labor law sections, and a certified civil mediator. Both he and his firm are AV rated by the Martindale-Hubbell system, and he is recognized annually in the Florida Super Lawyers publication. He served on the executive board of the Florida Labor Law section, as well as chaired the Wage and Hour and Equal Employment Opportunity Committees. He has co-authored the book entitled Employment in Florida, A Guide to Employment Laws, Regulations, and Practices. Mr. Richardson has also been a former field attorney for the National Labor Relations Board and Washington legislative assistant to U.S. Congressman J.J. Pickle. Mr. Richardson graduated from the University of Texas Law School. And he is going to be discussing with us today some of the wage and hour issues that are hot topics going on right now in the agricultural industry. Then we're going to turn to Mr. Carlton. He is the director of the Fruit and Vegetable Association's Labor Relations Division. Mr. Carlton's primary responsibilities are representing the association in labor-related legislative efforts on the federal level and coordinating members' use of the H-2A guest worker program and assisting with compliance efforts with labor law affecting agriculture. An industry veteran, Mr. Carlton held numerous management positions at Florida Citrus Mutual in Lakeland for 26 years before joining the FFVA in 2007, including serving as the Director of Production and Labor Affairs and Director of Grower Relations. Among his numerous accomplishments was designing a $400 million hurricane relief program for the state's citrus growers in 2004 and successfully pushing the U.S. Department of Agriculture to adopt that program. In addition to his duties at the FFVA, Mr. Carlton serves on the board and executive committee of the National Council of Agricultural Employers in Washington, D.C., and on the executive committee of the D.C.-based Agricultural Coalition for Immigration Reform. Thank you very much to both of our speakers for joining us today. I think we're going to have a very rapid-paced discussion. We're going to try and take some questions, but we only have just a few minutes to cover a lot of topics. So, well, that will get started with Mr. Richardson. Can you tell us what you think have been the most interesting and active topics that you've seen recently in the wage and hour world in agriculture?
Nearly all of it is interesting and active, too much so, as a lot of you well know. And a problem with practicing or even speaking on employment and labor law to agriculture employers is that you can never tell them anything they want to hear. No good news. And before I hit the topics, I did sort of a checklist that's under tab 2. That
in your bound materials.
In your materials, that if you'll turn to that, maybe we can move through the material. I was thinking of something to sort of start off with, and I said that, well, there's three components to a successful employment policy and program in agriculture if you're an employer. Be knowledgeable, be careful, and be lucky. You can do everything you're supposed to and still have problems, but you're going to have a lot more problems and a lot more exposure if you don't do what you're supposed to, or at least try. One thing, if you're starting on the outline, it's a sort of a hot issue, or can be an expensive issue. I think particularly in these times with somewhat the urbanization of Florida, it's not quite as it was as important as it was 2 or 3 years ago when there was so much land being turned over to housing developments. But a lot of you have mixed businesses. You have, because there's an agriculture exemption in the area of labor law for Fair Labor Standards Act and even under the National Labor Relations Act. And the one big point of the Fair Labor Standards Act, wage hour law, is that agriculture workers, if they fit the definition, are exempt from overtime. And the non-agriculture are not. And often through economies of force, using equipment, both in commercial ventures, landscaping, other type of things, you have people jump back and forth between your exempt and non-exempt, where they may lose the exemption. We could speak for a couple of days on who's agriculture and who's not, but there's a definition attached to here, and you need to examine, particularly if you have diverse operations, because you can even end up with people in your office that are eligible for overtime, and these overtime cases are very hot. If you turn on the TV, at any time of the day, you hear someone saying, "Did you work through lunch today and not get paid?" They call a BR 4111, we'll get you some money. You need to make that self-audit and determination of which of your part of your workforce is eligible for overtime and which is not.
And I would just call Mr. Richardson or call us if we can help you figure that out. But the important thing to remember with agriculture, I think if you correct me if I'm wrong, is that it has to be 100% in agriculture. So if you find one of your employees doing some office work for a day because you need to find something else for them to do, you lose that exemption for the week. So that's where it gets caught.
And logic usually doesn't have anything to do with it. Another issue that continues to be a hard one for agriculture, and it applies to other industries, but it really doesn't get applied like it does to agriculture, is determining who the employer is, because there's still a lot of people feel like if they're dealing with an independent contractor to furnish labor, whether it's harvesting or some other aspect, that they don't have any liability, and that's just not correct. You can sometimes not have any liability, but the courts, starting back in the 70s with a case called Griffin Brand out of the valley, packing house out of the valley of Texas, started creating joint employment. And for right or wrong, the corporate shield really doesn't mean much in labor and employment law. The courts find a way, and Department of Labor find a way to lump people together and step over the corporate line and find different companies jointly liable. So the independent contractor, in fact, somebody else is an independent contractor, doesn't mean if you've used them as a grower that you may not have joint liability. There's different tests, there's different ways. When this all started up, and it particularly becomes a problem in harvesting, and some employers decide, well, if I'm going to be held responsible for them, I'll just make them all my employees. And that has worked for some. It doesn't always work because you've been charged with a responsibility over something that's very hard because of the diverse nature of harvesting and the people that are involved in it to control. But some have gone that way. Another way, the one I sort of prefer, but it's up to a client, is recognize that you may have joint liability and do everything you can to make sure, if you're using an independent contractor, that without getting involved in this business, that you're doing business with someone who's going to comply with the laws or as best they can. And protect yourself with a contract. Make sure your field riders and supervisors know not to get involved with the crew members individually, deal only with the harvesting. Also, a problem that's been coming up, and I'll talk about a little bit on what's compensable time, is the field riders being accused of encouraging the harvesting contractors who are independent contractors, and maybe in this particular case probably weren't joint employers, but the allegation came out that the field riders for the grower were telling the people, the contractors, they needed to be there maybe an hour before the picking started. And I'm not talking about time to get washed off or that type of thing. And they said, yeah, and if you don't get there, you don't get the good picking. So if that's okay to do, if you want and the field rider said, well, I'm going to make sure I'm going to have a full crew that day, and I'm trying to find another one if they're not coming. Well, that's fine, but you may be held liable for setting the starting time, and that if they're getting there and waiting to start at your direction, then that may be compensable time, probably will be. So you need to see make sure your field riders understand what they should be doing and not doing. And everything that's involved in wage hour law, a lot of it, if you comply with it, sometimes runs counter to being productive. But you have to reach that balance.
And that's a good point for us to maybe jump off to. Can you tell us a little bit about what is considered compensable working time?
No. There's all sorts of little catchphrases. If you look at, it's probably page 2 or 3 of the outline, it's Roman numeral number 3. They always say it's a simple test, which means it's not. But whether you're waiting to be employed or employed to be waiting, the Department of Labor wage hour guys that come out to field, they use something, often they won't say that's what they're doing, but some of them will, that if they can construe it to be at least for the benefit of the employer, it's working time. And we have a particular problem in agriculture, particularly harvesting crews coming from all over and getting there early. And traditionally, a lot of the labor contractors feel like they have to pick up their crews early or somebody else will get them. That's particularly when they're getting crews from some sort of a gathering point. And so they may know particularly with when there's moisture restraints or when you can start picking, etc. They pick their people up early because then they know they have a crew for a day. Now, if you add an extra hour onto a working day for 6 days that week or 5 days, if the person's making a good wage, 12, 13 bucks an hour averaging out on a piece rate, you may not have any liability. You can be fined for not keeping accurate records. But if the closer the average wage gets down to the minimum wage, or contract wage, then all those hours that they come in and say you should have counted brings them below the set wage, and you have to pay that as makeup, and then it's double that. And if you get sued on it, it's also the attorney's fees. And if you look on, not only is the waiting time in the morning, normally the travel time at the beginning and end of the day is not compensable from the pickup point to the grove or the tomato field or wherever. But if that driver stops and picks up boxes on the way, picks up ladders, etc., or does anything other than drive straight out there, you're getting in where someone can argue that whole time becomes travel time becomes compensable. And you've always got the problem of people knocking off in the field of certain labor, people getting tired getting sick, etc., and they go get on the bus, and whether you have to count that time. It gets complicated because people ride on transportation. They can't go back to town. Generally, if you can document it that they truly were sitting on the bus on their own will, etc. It's also good to have a sign up where people can bring their own transportation out to the work area and they're not captured on the vehicles, on the company vehicles. Most of them won't do it, and during some of the disease areas, people didn't want different cars into their property, but you can have them park them in a separate area and then transport them into the field. But if it's compulsory group transportation, that causes some situations where Well, I couldn't go back to town. They brought me out here, and then it's whether is that compensable time. We would argue that it's not because the transportation was voluntarily. But
We're going to switch over now, I think, because of our time, to Mr. Carlton. But what we're going to do is try and take, if we have a few minutes at the end, we'll take some questions. And also, Mr. Richardson's information is in here. He has graciously agreed to answer any questions if you have afterwards. He'll be around a little bit today, but you could also get in touch with either he or I, and we can try and help you out. Mr. Carlton's going to talk with us a little bit about some of the hot button H2A issues going on right now.
Yeah, thank you. And actually, Dave gave you the good news, I guess. And my apologies for being late. St. Asphalt, the patron saint of the interstate, was oversleeping this morning, and there were 2 accidents on the interstate coming in, so I got a little backed up. I'm going to give you a little bit of the state of play of where we are with immigration reform, actually. It's kind of connected to H2A in a big way. And for background, there are about 1.2 million farm workers in the country, an additional 400 to 600,000 in dairy, livestock, and nursery. And estimates are that as much as 75% of those are here with false documents. Probably in the harvesting portion of the industry, that number is much higher. Understanding that, we have a move in Washington afoot to institute a mandatory E-Verify program throughout the country. The chairman of the Senate Judiciary Committee, Lamar Smith, has introduced a bill. They had markup on that bill this week, and it passed the Judiciary Committee Wednesday. In that bill, because we had spent so much time with not only Lamar Smith, and that's the we meaning agriculture, Agricultural Coalition of Immigration Reform, National Council of Agricultural Employers, a number of groups like that. I've spent a lot of time in Washington with Chairman Smith, with Speaker Boehner, and with some others. So although Chairman Smith, quite frankly, I don't think really wanted to, he included some provisions in his bill that he claimed would help agriculture. One was that returning seasonal workers would not have to be verified. And that's fine, but if everybody else in the country is E-verifying, then ICE and Homeland Security don't go anywhere but agriculture to look around. So that really didn't help it too much. And the other was to delay agriculture's implementation for 3 years, which just means it's a slower death. Interestingly enough, Congressman Howard Berman out of California introduced an amendment to strip the seasonal exemption out of the bill, and that amendment passed. So Chairman Smith's E-Verify bill has even less for agriculture in it than it did before. We have been working with a couple of members of his committee, one of whom is Dan Lundgren out of California. And Congressman Lundgren has become quite passionate about this issue, has a huge agricultural industry in his district. As I understand it, there was quite a loud discussion in the cloakroom of the House between Congressman Smith and Congressman Lundgren. The positive thing that has come out of this is that, not in committee, but off the floor, with a number of other congressmen around, Congressman Smith committed to Dan Lundgren that he would hold another hearing on Ag's impact on E-Verify, and that his bill would be in the final version of the E-Verify bill. Dan Lundgren had proposed an amendment which created a new guest worker program, what is termed a market-based guest worker program. And that means very little of the bureaucratic morass that plagues the H-2A program. It's essentially a market-based program where if a foreign guest worker has a job offer, he is allowed to get a visa, comes in, the market sets his wages, but he is free to move from employer to employer in the agricultural community. So that's kind of a positive. It may be a better place than we've been in a long time. I'm not comfortable that we're in a good place, but we're in a better place than we've been in a long time because we have some action. We certainly have Speaker Boehner's ear. Lamar Smith actually told Dan Lundgren that the speaker made him do it when he told him he would include his language in his bill eventually. So those are kind of positive things. The problem that we're dealing with right now is if E-Verify takes place, agriculture has one option, and that is the H-2A guest worker program. And the H-2A guest worker program is plagued with delays, with an adversarial Department of Labor approach to it. As an example, the National Council of Ag Employers last year commissioned a significant survey of H-2A users about the program itself. One of the things that was turned up from DOL records during that survey was up until 2009, the average number of appeals of applications per year was 18 in the program. The rules changed in 2010. Department of Labor became much more difficult to work with. And last year, the number of appeals was 442, 90% of which DOL lost, meaning they were wrong in denying the applications. That certainly indicates an attitude problem. There are a number of other issues with H-2A, delays in getting the workers there. 72% of the respondents said they didn't get their workers on time under the program. Last year, there were about 6,500 applications filed in the country, bringing in about 60,000 workers. DOL has a regulatory mandate to respond to those appeals within 30 days of the date of need. They missed that time frame 50% of the time. We could write a book, and actually NCAE did write a book on the problems with the H-2A program. But we're moving forward. We're not, we haven't slowed down. We have a lot of attention in Congress right now. There, I think, is some real concern that if the agricultural community in particular makes enough noise, it could jeopardize E-Verify. So Chairman Smith is a little concerned about that. We're not certainly up there supporting E-Verify, but at the same time, we recognize that we need some solutions. We need some guest worker solutions. Clearly I know people, for the most part, don't like to hear the term that Americans won't do that work, and that's probably a misnomer. But clearly the right thing to say is there aren't nearly enough Americans that will do that work. In the H-2A program, one of the things that is required is filing with the job service, job orders with the job service. The survey itself showed that 5% of the people that were hired through that lasted the season. I did a survey just among the H-2A users that we file for that showed that they hired, for 1,800 jobs, they were able to hire something like 330 domestic workers in those jobs. 4 of those domestic workers lasted the season. The vast majority of them were gone within a month. We desperately need, as agriculture, that good, stable, legal foreign workforce. And I encourage you, if you have concerns, to voice them to your congressman. I can tell you that they hear from people who don't want immigration reform a lot. and they don't hear nearly enough from agriculture. Dennis Ross is on the Judiciary Committee. For those of you who are in his district, it would be a good idea to contact him. Congressman Deutsch from South Florida is on it, on the Democratic side. They need to hear from us. The next step is hopefully to have a hearing on ag's problems with E-Verify. Interestingly enough, Chairman Smith also has a guest worker bill he's proposing, which the good news is it actually repairs some of the real problems with the H-2A program. But our concern is the H-2A program structurally will not be able to handle the increase that it would take if we had E-Verify. That 6,500 number in the country filed, we estimate if E-Verify goes into effect, number of applications in the country will have to go to 150,000. And quite frankly, DOL can't handle it and probably has no interest in handling it under the H-2A program. It would be great to have Chairman Smith's bill passed and repair some of the problems with the H-2A program, but quite frankly, it's not enough. We need an alternative beyond that. And that's kind of what we're working for. So I'll leave it at that.
Okay, well, thank you, Mr. Carlton. We have about 2 minutes. If anybody has any questions that we can pose to either our panelists? No, it sounds like there's an interesting interplay between the immigration reform issues and the H-2A and E-Verify issues, so we all need to try and balance those objectives. Mr. Carlton, I think, has to scoot right after this meeting because he has another meeting to go to. Is that right?
Stick around for a little bit.
Okay, he's going to be around for just a few minutes. You might be able to catch him outside if you do have questions on that. Thank you again for your attention to our very first panel, and we appreciate very much Mr. Richardson and Mr. Carlton for coming, and have a good rest of your day.